You may have read elsewhere on my website that your protections against creditors are better outside of bankruptcy than they are in bankruptcy court. Many of my clients, after I have completed an asset protection planning session, will ask me, what if a creditor forces me into bankruptcy by filing an involuntary bankruptcy petition? My name is Jonathan Alper, and I'm an asset protection planning attorney in Orlando, Florida. So what are involuntary bankruptcies? How do they work? Well, they're very complicated. Here's an example. If you have more than 12 creditors in your life, it takes 3 or more creditors to get together in a team and jointly file an involuntary petition. And most people have 12 or more creditors. Only if you have less than 12 creditors can one aggressive creditor by themselves even attempt to force you into bankruptcy. Another complicating rule is the rule that no creditor can file against you or even qualify to count as a petitioning creditor among the 3 if there's a bona fide dispute between you and the creditor. So if you have a lawsuit, the creditor's suing you, you may be countersuing, and there's no final judgment, then there's a bona fide dispute between you and that creditor, and he cannot be one of the petitioning creditors. Understand that if you have a judgment and have filed an appeal, that does not disqualify the creditor. An appeal does not prevent a creditor, or does not create a bona fide dispute and prohibit a creditor from filing against you. In practice, involuntary bankruptcies are rare. And why is that? Well, first, they're complicated, expensive, and very few attorneys have the experience and knowledge to file an effective involuntary petition. The other thing is that if a creditor files a wrong petition or an inaccurate or a premature petition, the court must sanction the creditor and possibly even the creditor's attorney. And if it finds that the creditor filed in bad faith and he should have known that he should not have filed the petition, the court can assert punitive damages or award punitive damages against that creditor. The other thing is that, as a practical matter, an aggressive creditor wants to compete or is competing with all the other creditors, and that aggressive creditor wants to maximize its own recovery. But if the creditor forces you into bankruptcy, and the bankruptcy does enable the trustee to recover some assets, the creditor or creditors who started it, who did the petition, they have to then share the recovery among all the other creditors. So often it is against the creditor's interest, even if they think they can get some money in an involuntary, to start a proceeding where their hard efforts and their expenses end up being shared among all the other creditors who happen to be creditors in your life. If you're concerned about a creditor filing an involuntary bankruptcy against you, give me a call, and I'll have the opportunity to explain these very detailed rules to you more fully to make sure you understand what your risk really is. My name is Jonathan Alper, and my phone number is 407-444-0404. Thanks for watching the video.